Supplementary list. Item number 1, pronouncement of judgment. Item number 1.
Where's the petitioner?
Sir Biban Kinta.
I'm here, Your Lordship. I'm not keeping well, so I have not come to the court, Your Lordship.
Yes. In review of the matter, therefore, the petitioners for the period 3F appointment having been allowed all other benefits towards regaining their service with regard to leave paid increment as per FR 28A, this court, by giving liberal interpretation to the letter dated 19/2/2021, sees no reason to deny the petitioners added benefit of being governed by the old pension scheme of 1983 also. As such, consequently, Clause 4 of the impugned letter dated 19/2/2021, which contradicts the benefit allowed by letter dated 27/8/2007, is hereby set aside, and the respondents directed to free as the petitioners under the old pension scheme, namely the Meghalaya Civil Services Pension Rule 1983. The petition stands allowed and disposed of.
Much obliged, and thank you, Your Lordship.
Nothing to thank, just citing the law.
Item number 2 to 5.
Much obliged.
The recruitment of the writ petitioners, as per the facts laid out here and above, can be said or held to be irregular or illegal, and at the most, due to stipulation in advertisement, that efforts should have been first made to fill up the post by deputation, including short-term contract, be said to have been made with a slight deviation from advertisement. Instant case recruitment rules being followed and the approval accorded as per due process, the appointments of petitioners which are neither illegal or irregular are therefore liable to be reconsidered by the respondents for realization of appointments subject to the rules as contained in service bylaws of Nectar. Accordingly, in view of the findings and discussions made and above, this petition allowed impugned letter dated so-and-so here was set and inquiry.
Any mention?
Yes.
Yes, Your Lordship.
Yes.
I beg to mention item number 28 of the hearing list. 28, Your Lordship. The leading counsel, the leading counsel in this matter, Your Lordship, is not keeping well, Mr. Chanda. He's having some personal difficulty. We have already taken the consent from the other side.
Yes, 2 weeks. Yes.
Much obliged.
May it please, Lordship. Lordship, I beg to mention item number 30, Lordship. In fact, it's a joint mention, Lordship. Item number 13, Lordship. Joint mention, Lordship. I'm making a joint mention, Lordship.
Item 30.
A joint request, you mean?
Lordship.
Why?
Lordship, some difficulty, Lordship. Parliament matters are there, Lordship.
What part of the matters are there?
Lordship, before the
weeks,
other
yes.
court, Lordship.
When the other court? Okay. Yes.
Deeply obliged.
May we please, Your Lordship? Your Lordship, I beg to make a mention for item number 27. I'm appearing on behalf of respondent number 6, Your Lordship. Your Lordship, if 2 weeks' time may be granted, because only yesterday we were able to obtain the signatures of the concerned officer, Your Lordship.
2 weeks time for?
No, for us to file the affidavit in a position.
You haven't filed affidavit as yet?
No, Your Lordship, actually, because of some defects, Your Lordship, we had to send back the affidavit in a position to correct
Just
it.
after 2 weeks, yes.
Lordship,
Obliged, Your Lordship.
can I make a submission, Lordship? They have already served a copy to us, so in advance we have already filed reply to their
No,
affidavit.
only the signatures to be obtained
You
the same
already filed
thing.
rejoinder also?
Because
That's very prompt, it's very good, yes.
No, last thing.
If there is no such changes, then it may
No,
remain
no,
on
there
the
won't
board.
be any changes, Your Lordship. Only the signatures will be there.
Obliged, Your Honor.
Obliged, Your Lordship.
Yes. Make it quick, yes.
Yes, Your Lordship. Your Lordship, I beg to mention item 17, Your Lordship. Your Lordship, in this matter, we are yet to file the list of paper book, Your Lordship.
We are making the paper book.
Yes, Your Lordship.
17.
Yes, Your Lordship.
Who's for the other side?
No objection.
2 weeks, yes.
Highly obliged.
The request of the appellant for some more time to prepare paper book, yes.
I'd like to mention item 22, 23, connected matters, Your Lordship. Looking for some accommodation from the other side.
22, you're for the, who's for the petitioner 22?
I'm for the petitioner, Your Lordship, both 22 and 23.
Lordship,
Yes.
in item number 22, I'm on behalf of respondent number 8 and 9, and 23, I'm on behalf of respondent number 9
Yes.
and 10.
You're opposing the adjournment.
We are ready, Your Lordship.
You ready? They're ready.
So I'm praying for some time, Your Lordship, some accommodation.
You don't want it to be adjourned. Is there some urgency?
If they're asking praying, then it's fine.
She's
Your
ready.
Lordship.
She's not allowing your adjournment.
It's fine, Your Lordship, if they
It's
have
fine.
some
Okay.
difficulties.
Yes, 22. 20, after 1 week, yes.
Obliged.
It's good. At least some objection to adjournment. Otherwise, yes. 1 week. Okay.
Much well.
Yes.
My lord, I beg to mention item number 31, Lordship. 2 weeks, Lordship. Here I have some difficulties today, Lordship.
Lordship, you have no objections.
Okay, 2 weeks. yes.
Lordship.
Please, Your Lordship, I'd like to beg item number 20.
Now, item number
Mention item number 20.
20.
Yes, sir, if this matter can come up after 2 weeks.
Dr. Mosika is not here today.
Your Lordship, in fact, he'll be occupied in the division bench.
1 week, okay. Yes.
I beg to mention item number 33.
So list exhausted.
Let the matter come up after 3 weeks.
Yes, infructuous.
Sorry.
What's the matter about?
It's
wine
regarding
store?
Yes, Lordship.
yeah, wine store.
Here, Lordship, that the person to whom that license was issued was not issued, notice was not issued to him, to her, Lordship. Private respondent, Lordship.
Pending for hearing.
Yes.
It's pending for
The notice was not issued to her. She is the...
You didn't take steps.
In fact, the court did not issue the notice. The court sought for instruction from the state lordship, and I filed.
What happened?
I filed my reply.
What
lordship.
instruction is it in the
No, the procedure was followed.
Then let notice issued as Act of number 31, 33. Sorry. You're sure about that?
Yes, lordship.
It's good you reminded the court. Otherwise. Oh, yes. Mr. S.A. Sheikh, though this matter has appeared in the hearing list, Mr. S.A. Sheikh has apprised the court that notice is yet to be issued to the to the private respondent number 6. Accordingly, petitioner to take steps for issuance of notice on respondent number 6 within 3 days. Okay. Just after 2 weeks on the order column. Yes.
Your Lordship, I beg to mention item 21, Lordship. Conducting counsel is out of station, Lordship.
Who's conducting counsel?
Espandi, Lordship.
Espani is your senior?
Yes, Lordship.
No objection.
1 week, yes.
Obliged, Lordship.
Your Lordship, I'd like to mention item 26, Your Lordship.
Objection, Your Lordship.
Happy that being adjourned. 2 weeks, yes. Yes. Call out.
Supplementary list, item number 6.
May please, Your Lordship, let the matter be called up after some time, Your Lordship.
What's the matter about? Yes.
Pension matter, Your Lordship.
Pension matter?
Yes, Your Lordship.
You know the facts of the case?
Your Lordship, I haven't read this.
What's it about?
Your Lordship, in fact, the petitioner herein is the youngest daughter of the deceased mother who has been receiving the pension earlier. But now she has come here to transfer the PPO in her favor, Your Lordship.
So why she has to come to court? Was any impugned letter?
No, Your Lordship.
State Bank. Who's at fault?
My lord, here what happened is they're saying that they have denied my pension only for want of a notification notifying my name in the EPPO, my lord. Now they have made me run from pillar to post, my lord.
No, are you against the bank or the pay and accounts officer?
My lord, it's a pay accounts office. The concerned office is the Accountant General Meghalaya, my lord. My mother was working there. She died, and subsequently she was survived by 2 daughters. My elder sister was initially getting the pension, but when she attained 25 years of age, unmarried, she was not entitled anymore. And I'm still below 25 years and unmarried. Though immediately when it became due, I have applied for the pension because my name was, I'm also one of the nominee. Now, my lord, all the pension papers, whatever requisite documents were forwarded, my lord.
Where's that MSEB Pasa? You didn't serve notice to them beforehand.
Copy to the government.
3 can accept notice.
Your Lordship, in fact, only for 1 we will be accepting.
Only number 1, yes.
One.
Huh?
Heard Mr. P. Ubin, the counsel petitioner issue notice. MS Umthao is present on behalf of respondent number 1. Petitioner takes step issue notice to the other respondents 3 days, yes, also 3 weeks, yes.
3 weeks. Obliged.
Item number 7.
You file affidavit?
Yes, my lord. They have filed an affidavit, my lord, and this calls for a rejoinder, my lord. But however, my lord, I like to point 3 documents, my lord, which will fortify it and which, to my humble...
You put in the rejoinder then.
My lord, but now, my lord, to my humble submission, my lord, these 3 documents which I'm going to show to my lord is good enough, my lord, good enough to stay the appointment order, my lord. The first of all, my lord, kindly look at, may I draw my lord's attention to the affidavit filed by the respondent number 4, my lord. Respondent number 4.
1 and 2 is MPSC?
Yes. 1 and 2 is MPSC, my lord.
Number 4 is?
Number 4 is one of the candidate who got selected in my place, my lord.
Okay.
So, my lord, one document that I wanted to show, my lord, is page 20, my lord. Page 20, annexure 1G.
Of whom?
Of the respondent number 4. Of the private respondent number 4.
It's not here on record, number 4. When did you file it?
I've received last night. I don't know whether they have filed or not.
1 and 2 is here, number 4 is not here. Number 4.
Show me that.
Oh, yes, it's here.
My lord.
Yes, number 4.
Yes, my lord. My lord,
page?
Page 20, my lord, annexure 1G. This is an annexure 1 in Colin, and this all has...
One second. Yes. Just hold your horses. Page?
Page 20, my lord. Annexure 1G.
Yes.
My lord, now, kindly look at this. This is to certify that Alvarina Nongsage of Open Unit has successfully undergone basic course for Scoutmaster conducted at State Headquarters, MBSG, Shillong, from 19th April 2017 to 25th April 2017. Mark the year, my lord, 2017. And what is this? Is and basic training. My contention was that how could she be appointed as an ASO in the year 2016? My lord will recollect. My challenge to this was that 2016 she was not an SOC, and even...
You file rejoinders then?
My lord.
Yes. My lord. If you're pressing for interim orders, then you file a business application for interim orders.
My lord.
Yes, affidavits have since been filed by all the respondents.
Yes, my lord.
As such, the matter is ripe for hearing. List for hearing after 2 weeks.
Rejoinder in the meantime.
Rejoinder we file in the meantime. Yes.
My lord. Obliged.
Daily list. Item number 1.
May it please your Lordship. Lordship, this matter, we were required to prepare a paper book. That's been done, my Lord. Copy has been given also.
Where's the paper book? Is you have examined it?
I have received just now, ma'am.
I gave him
It's
just now.
taken after 2 weeks.
You examined it, whether it is, all the materials are contained there. Yeah. But the Council of the Appellant submits that the paper has been prepared and has been filed with HRA. So please be allowed to peruse the same to see whether all the materials have appeared. Yes, this after 2 weeks.
Item number 2.
Yes. What did you do?
Please, Your Lordship.
What about the remaining respondents?
Lordship, in this matter, I'm appearing not for everyone, but only for 7, 8,
7 to 8, 9, 10, and 13.
And 13, my Lord. So affidavit has been filed only by 10, adopted by the other respondents who I represent, my Lord. The non-represented respondents, my Lord, I cannot speak for them.
That means 7 to 10.
Plus 13.
One to four. You file. That means 5 CEO.
Not.
Who's the appearing for CEO?
Not represented.
WAF board.
Not represented.
Abu Saleh. Who's Abu Saleh? Abdul Saleh, sorry. Who's he? Officer of CEO. Who's he? Why is necessary party? Abdul Saleh, who's he? Officer of CEO.
Lordship, that is number 6 is one of the members of the board.
Okay. So also 9 and 10.
Yes, my Lord. The rest following number 6 are all members, my Lord.
So you're appearing for 7 to 10.
7 to 10 plus 13.
7 to 10, that means you're appearing for 7, 8, 9, 10, and 13 is Nurjahan Mehraj Wajri.
Yes, my Lord.
Okay, 14 struck off, that means that leaves only 11, 12. That means that only 5, 6, 11, and 12.
Yes, my Lord. Yes.
No one's appeared on their behalf. They've all been served.
Lordship, in fact, for respondent 14 also, we have
been struck off.
No, Your Lordship.
But substituted.
Substituted, Your
They
Lordship.
substituted by
By
Shehnaz Abbas.
Abbas. Yes, Your Lordship.
You've taken steps.
Yes, Your Lordship.
They've been served.
Yes, Your Lordship.
What about, are they all been served?
Yes, Your Lordship.
So it has been submitted by Mr. S. Jindal that only one affidavit will suffice.
For all of them.
Yes, one affidavit on behalf of the Contempt will suffice for the respondents 7 to 10 and 13. Stop. On behalf of the respondents, the affidavit is already on board. Stop. Though it has been submitted that notices have been served to all the remaining respondents, including the newly implemented respondent number 14, no appearance has been made on their behalf till date. You want to file rejoinder or no?
Yes, Your Lordship.
You want to file rejoinder?
Yes, sir.
Lordship, they've been.
The affidavit?
They've taken almost 6 months not to file a rejoinder.
Okay. Well, this is a matter for hearing then.
Published.
If they don't appear, we'll let it go ex parte. Yes.
Item number 3.
Lordship, I appear for the petitioner here.
Yes. Yes, as from Thao. Yes. There's a pasque. When the contract? When was the contract period?
Contract.
When? 2007.
2007, Your Lordship, yes.
2007, Your Lordship.
Have you filed affidavit state?
So far, the state has filed, Your Lordship, yes. We filed in 23, Your Lordship.
MSS Room Thao on behalf of respondents number 4. Please for further 3 weeks time. We need to file affidavit, yes, no longer.
Your
Got the old, yes.
Lordship, in the meantime, I may be permitted to file a rejoinder to the State Government.
In fact, similar matter also is there. That is WPC number 444 of 22. Your Lord. If it can be listed along with this.
Which one is this?
Lordship, that is WPC number 444 of 2022. Your Lord.
2023.
Yes,
This matter also can be tagged with this.
Also Mr. Pasque, Mr. Ndi Shulai, Leonard AAG, as well as Mr. Submit that a similar matter being
Lordship.
WPC
444, Your Lordship, of 2020. Yes, Your Lordship. 22, Your Lordship.
Maybe listed together in the
Lordship.
application. Yes. Listed two matters together, next date.
Apply, Your Lordship.
Item number 4.
Deeply obliged, Your Lordship.
I fully file my rejoinder.
I am for the state respondent. But
List
this
for
will come up
hearing?
for hearing.
No, Your Lordship. I fully file my rejoinder.
It's listed for hearing?
Yes.
Please submit that the things are complete according to this matter for hearing and usual course.
Item number 5.
File rejoinder.
My lord, file rejoinder.
Very good.
Now, my lord, we have to file, it's important, rejoinder against the affidavit also filed by the Power Grid and respondent number 13, my lord.
Against rejoinder, you file against whose affidavit?
Now against state, my lord.
Number 1.
Number 1.
Now this Mr. Sani appearing for
the state, my
7, 9, and 10.
Lordship.
One is
2, 7,
Mr.
9,
Nath.
10. Lordship.
You've excuse me. You already filed against 2, 7, 9, and 10.
Lordship.
The
It
rejoinder
appears
is
to be
filed.
against the state.
Against the state.
No, you are appearing whom 6 and 8 is?
My lord, 6 and 8 is NECA.
Then 11 and 12?
11.
That's KHDC, my lord.
Then 13?
13 is private party.
So who has not filed affidavits?
Who filed?
Everyone's filed.
Everybody, state has filed, my lord. This, I think.
MCL's filed.
My lord, you are not filing, it's on record, my lord. You make a submission.
To which respondent's affidavit you want to file rejoinder?
States,
Mr.
my lord.
Nath?
They filed a rejoinder to our affidavit.
No, to which, what are the rejoinder you want to file to whose affidavit now?
Now, affidavit number, respondent number 13 and the respondent number, Power Grid, my lord. Respondent number 3. 345.
You're paying Power Grid.
Yes, my lord.
Yes, Mr. Nath submits that. Yes, Mr. H.R. Nath submits that the rejoinder has been filed to the affidavit filed by respondents 2, 7, 9, and 10. He prays that he be allowed some time to file affidavits, to file rejoinder the affidavit filed by the respondent 3 to 5, as also respondent number 13. Prayers allowed just after 2 weeks, yes.
Item number 6.
Affidavit filed.
Affidavit, we have
Lordship, we filed the affidavit, Lordship.
Yes.
We have received the affidavit, my lord, where it has been denied about the entitlement of the EPF fund, my lord. Now, my lord, I have to give the rejoinder.
Rejoinder is also, yes, Mr. H.R. pays for 2 weeks time for rejoinder. Just thereafter also.
Item
Much
number
obliged,
7.
Lordship.
They respondent 1 to 4.
May I please, Your Lordship?
File.
We have received yesterday, Your Lordship.
So what do you want to do?
Your Lordship, we have received just yesterday and we are yet to go through its content thoroughly. And with regards to the affidavit in opposition filed by respondent number 1, 4, 5 and 6, we are filing rejoinder by today itself, Your Lordship.
Okay. Your MSDD Fancon?
Yes, Lordship.
Yes, MSD Fancon and Counsel with Petitioner submits that rejoinder to the affidavit filed by number 1 and 4.
Your Lordship, filed by 2 and 3, we have received yesterday.
No, the other rejoinder.
It is 1 and 4, 5 and 6, Your Lordship.
MS also submits that to the affidavit filed by response 1 and 4, 5 and 6. The rejoinder will file the course of the day. However, she prays for further time to file the rejoinder the affidavit filed by response 2 and 3. According list after 2 weeks for rejoinder. Yes.
Apply, Your Lordship. 7, same, Your
7
Lordship.
is connected matter. 8.
7, 8. Same, Your Lordship. Same order, Your Lordship.
Yes?
7, 8 connected. 7, 8. Obliged.
9.
Lordship, in this matter, we have already taken step, Lordship, to respond to number 5 and 6. So we may be allowed some time, Your Lordship, to file affidavit of service.
5 and 6?
Yes, Lordship. Respondent number 5 and 6.
You will file affidavit?
No, Lordship,
You
we
pray
may be
for
given
whom?
some time.
Your Lordship, I'm entering appearance on behalf of respondent number 5.
Number 5 is whom? What about 6? 6 is whom? Number 6. Yes, Mr. Sinkram, correct? Has entered appearance on behalf of number 5 today, but no appearance yet been made upon number 6. Petitioner please for not to file affidavit indicating service for number 6. Just after, you'll file affidavit? Yes. Yes, just after 2 weeks for
Your Lordship.
affidavits by the remaining respondents. You already filed affidavit?
We already filed, Your Lordship, yes.
Item number 10.
Apply, Your Lordship.
May I please, Your Lordship? Lordship, I have received affidavit in opposition on behalf of the respondent number 3, Nehu. But Your Lordship, I beg to submit that as per the affidavit, it is the Ministry of Human Resource Development. They have stopped funding. So Your Lordship may kindly direct the Ministry of Human Resources to file the affidavit. Otherwise, it is...
You will stop the funding. It must be a scheme to stop the funding, then your job is
Lordship,
gone.
unless the affidavit come, how the matter can be closed, Your Lordship? For the interest of justice, Your Lordship, may be pleased to direct the respondent number 1.
You already filed.
We will be filing in the course of the day, Your Lordship.
You filed the course of the day?
Yes, but I have received...
And my lord, I have already filed yesterday, my lord,
Very good.
for respondent number 2.
Yes. MSP Agarwal submits that is okay. Is there an office note? Yes, office note indicates that affidavit House 102 has already been filed. Stop. MS Chalam on behalf of respondent number 3 submits that the affidavit filed in the course of the day. So, MS next paragraph. MS S. Barachaji, counsel for the petitioner, has however prayed for directions that respondent number 1, who is in fact the authority to sanction the schemes, be asked to file affidavit. Stop S. Rumthao to take so on behalf of Vice Dr. N. Mozika to obtain instructions. Yes. Just after 3 weeks, yes.
Much obliged.
Obliged, my lord.
Item 11.
Not yet got instructions.
What instructions?
For some time,
What's the matter about?
It's a matter about regularization.
Regularization?
This is pertaining to SSS school, my lord.
And Mr. Sheikh? For a time, for the 2 weeks time allowed to respond to instructions, file affidavit. Just thereafter.
Item number 12.
May it please, Your Lordship.
Rejoinder file.
My lord, I have received, I
You
have
filed
just
it-
received the copy of the rejoinder.
Unless the party submit that the pleadings are complete, this matter for hearing.
File in due course.
Legal.
Your Lordship will file in the due course of the day.
You not filed, you haven't filed it?
Yes, Your Lordship.
Mr. Sonso submits the rejoindly filed the course of the day. Accordingly, it's a matter for hearing usual causes. Just on Sonso. Yes.
Much obliged.
After file.
I seek some more time, Lordship, to
Why?
file the counter affidavit.
3 weeks time was given last time.
So vacancy is out of
for
station.
for the 2 weeks time. We'll have to do it. File it, file it.
Obliged, Lordship.
14.
Your Lordship, in this matter, I'm praying for 2 weeks' time, Your Lordship. We're yet to receive instructions.
For the 2 weeks time, is prayed, allowed to respond to file affidavit. Just thereafter and so on.
15.
File obliged.
Yes, what instructions we received?
Your Lordship, we filed our affidavit, and in page number 9, we've clearly stated the reasons also, Your Lordship.
Why you appoint another person in place of a petitioner?
Your Lordship. If I can kindly take you to page number 9 of our affidavit, Your Lordship, 20E. If I may read, Your
9?
Lordship. Page number 9.
No problem.
E of the affidavit, if I may read, Your Lordship, that day after the petitioner approached this Honourable Court by filing the instant writ petition, and this Honourable Court by order dated so and so, passed in so and so case, was pleased to direct that accordingly it is provided that in the interim until the next date, one post of LDA should be kept vacant, awaiting further orders from this court. However, as stated above, the offers of appointment were issued on 19/02/2024 prior to passing of the interim order dated 23/02/2024. Further, the appointees have also submitted their respective acceptances of offer of appointment. The petitioner has not submitted any letter notice regarding the interim order dated 23/02/2024.
You think this is an excuse?
Your Lordship.
You constantly think it's an excuse. You'll ask the director to appear personally then.
Your Lordship, also, if I can take you to paragraph 20F also, that a total of 10 posts of LDC were advertised, and out of the above, one post was reserved for PWT category. The said post could not be filled up due to non-availability of suitable candidate. One of the selected candidate, namely Mr. So-and-so from Delhi, is selected in the
This is a very dodgy submission made in this para E.
Your Lordship, we had even filed an RTI regarding some of the documents.
No, not that. I mean, it's very dodgy in the sense that to say that 23rd, 4 days prior, even then it could have corrected it after the order came. And had submitted letter notice regarding, do you not intimate the authorities that the respondents that there was an interim order?
We have already did. We already
you have
did
proof
that.
of that?
I will have to check with the conducting council, Your Lordship.
Otherwise, this will be very serious, and that the conducting council is not informed also.
And Your Lordship, we
who
will
assigns the affidavit? Director. We'll see. Yes, an affidavit has been filed by the respondents. MSS Rumthao Learned Council has taken this court to para 20E, stating the reasons for why one vacant post was not been kept vacant. The reasons stated therein. I want to see anything other than vacant. The court will examine the same on the next date. Meanwhile, petition to file the rejoinder in 1 week.
Yes. 16.
Well, it's video order dated 18/3/2024. I'm sorry, Malik, I beg to appear for the petitioner in this matter. The respondents had to come back with instructions with a order dated 18/3/24 of this Honorable Court.
Your Lordship, in fact, we are yet to obtain any instructions.
What's the matter about?
Your
Malak, the petitioner was declared unfit qua medical grounds, my lords, which was, my lords, incorrect because they were not even in the guidelines. My lords will remember this case was about not straightened teeth, this occlusion of teeth, which is, my lords, merely that the teeth was unaligned.
Yes, why can't you get instructions?
Your Lordship, we have yet to receive instructions.
Yes,
Your
MSS
Lordship.
Rumthao submits and instructions read to be received. This is a matter of 1 week. Instruction be obtained before the next date positively.
Hearing. Supplementary list item number 8.
Lordship, I'm only praying that this matter be called up after some time, Your Lordship.
After some time, the counsel is not there.
Yes.
Yes.
Daily list 18.
The initial matter will be taken after the outcome of the next matter, my lord.
Call of the next matter.
The next is suspension of a linked over.
All the parties are here. Call out 19. 19.
19.
My lord, in the last occasion, directed me to obtain instruction as to whether, my lord, the chief should conduct the inquiry by himself, or, my lord, he can appoint others to conduct the inquiry and complete, my lord. I received the instruction from the chief. My lord, he has, my lord, in fact, selected two, since my friend's side has a reservation over the form inquiry officer I have nominated earlier. So he has, my lord, selected two neutral persons. As an inquiry officer, and this inquiry officer, if lordship permits, they will conduct the inquiry and give a report to me within time. My lord, he's the link door after Nong Posopo.
Yeah, agreeable to this, Mr. Ninja, Mr. Prasad.
Your Lordship, I'll just have to see instructions on this.
See, you've seen the last order.
Yes, Your Lordship.
Because you have actually made out the case that there's collusion.
Yes.
With regard to, because he recommended the name of the persons acting to come as linked also, right?
Yes. Just permit me 5 minutes. I'll just see some
5 minutes?
from the senior counsel here, Your Lordship.
Who's the senior counsel?
Mr. Musika is there. It's on legs, Your Lordship.
How will you know whether this person is suitable or not?
Your Lordship will contact through the
Your client only will know.
Yes, Your Lordship.
Yes, take down pursuant to the order dated 21/3/2024, whereby this court had observed that in the interest of justice, a de novo inquiry should be held which is free and fair. Stop. Mr. H.L. Sangreso, on the earlier date, had prayed for instructions, has prayed for time to receive instructions as to who would be the proper inquiry officers to conduct an impartial inquiry in the proposed de novo inquiry proceedings. Stop. Next paragraph. Today, the next senior counsel has supplied the names of two persons, namely, one, Relestar Lingdo, RELESTAR Lingdo, and two, Shaiborlang Walang. Stop. Next paragraph, Mr. Pasa raised that he will allowed to obtain instructions as to whether they have any objections to either of these persons conducting the inquiry. This is matter after 1 week.
1 week.
1 week. Yes. Copy of the names supplied by Learned Senior Counsel is taken in the mid part of the record. Is
18.
18 list together after that. Why you want to 18 now? Why? That inquiry will have a bearing on 18.
Now I don't. If that order is set aside, that order of suspension, then you can proceed.
No, once they accept the name, then consequential orders have to follow for de novo inquiry. Then order goes. Yes.
24.
Yes. This Dr. Mozika not being around is creating a problem for the court.
My lord.
Yes.
The agreement. What is it, Justice?
I'll have it informed, Your Lordship. However, just after some time, Your Lordship.
Yes, Mr. Kumar. You
My
ready with
lord,
the
then
matter?
item number 24 and 25 may be taken some other day, my lord.
Why?
After 2 weeks, my lord.
On the prayer counsel for the petitioner, this matter, next matter, 22 and 24.
24 and 25.
24 and
24.
24 and 25,
After 2 weeks.
my lord. Be fair.
29.
Yes. Where's your opponent?
My lord, he was here, my lord.
Yes, what's the matter about?
My lord is pertaining to issuance of a ST certificate, my lord.
ST certificate?
Yes, my lord.
Yes.
My lord, the petitioner herein is the adoptive mother of Master Frankie Nosfong. She had adopted Frankie by adoption order dated 24/7/2017.
What is going to show the name of that person?
Pardon me. Yes, Your Honor. Yes, Your Lordship. It's just the insertion of Miller into the surname.
Where's the state respondent? Why did they say they couldn't insert?
My lord, they had insisted on...
Why? What was the problem?
My lord, in response to the representation that we had initially made, they had asked for the scheduled caste certificate, scheduled tribe, Khasi tribe certificate, Your Lordship. The same can be seen at Annexure 6, page 33 of the petition.
Page?
Page 33.
33?
Yes, Your Lordship. This was the reply to the representation made at page 27, yes, where they had given the reply that the petitioner had not applied through the online mode and that the additional documents were required for the same. Now at point 2 and point 3, Your Lordship, they had stated that the petitioner requires an NOC from the clan, and at point 3, a Khasi tribe from the KHEDC, Khasi tribe certificate from the KHEDC.
Yes. Where's the counsel of the state? Yes, where's the counsel for the state?
Mr. H. Abraham is the counsel, I've been informed.
Mr.?
Mr. H. Abraham.
Where's he?
My lord, he is on the, before the other court, he's coming, my lord. My friend can start his argument. He's here, my lord.
Yes, stop. So, Your Lordship. You ready with the matter, I hope?
Yes, Your Lordship.
Very good. Yes.
My lord, pursuant to the reply given by the respondents, the petitioner had filed the petition stating the same that these two documents which are requested by the respondents are not required and are arbitrary against the Lineage Act. So, Your Honor,
How?
pardon?
How? You're saying they're not required?
Not required,
Why?
Your Honor. Your Honor, Your Lordship, the fact is that the child of the petitioner, the adoptive child of the petitioner, is already a Khasi, member of the Khasi scheduled tribe, and that is is already holding the certificate for scheduled tribe. At page 12 of the petition, Your Honor, annexure 2 is the existing scheduled tribe certificate of Master Frankie Nongspong.
Yes.
So, Your Honor, Your Lordship, the fact is that Mr. Frankie already has an existing
Scheduled tribe certificate. Yes, and what do you want now?
We just want an insertion of the name Miller into the as a middle name for Frankie.
What was the reason given by the state for refusing? What's the reason given, Mr. Abraham?
Your Lordship, what happened is that whenever any applicant apply for this scheduled tribe certificate, they have to apply online. Then the matter will be taken up before the screening at district level screening
See, it's not a fresh
committee.
application. You don't have any provision for just an application for change of name.
No, what about the birth certificate? All the documents to be enclosed. Then the committee will peruse all the documents, and if the committee find it okay, then they will approve it.
But what's wrong? Why this child was already having scheduled tribe certificate?
They have not applied, Your Lordship. So we cannot decide.
Applied?
We have applied, Your Lordship. Your Lordship,
Where's the application?
after the respondents have filed an affidavit, we had made an online application to the same effect. It can the same can be seen in the.
We settle it within 1 week.
Your Lordship.
Take down it.
The committee sits once in a month. So
Very good. They'll sit tomorrow.
If this matter will be, one month's time may be given, Your Lordship, because the matter will decide by the committee, Your Lordship. And if they agree, they can always go for an appeal before the state screening committee.
Talk about appeals. This is the requirements that have been asked for. Tribe certificate is only for doubtful cases. Now the only thing that they're seeking is for insertion of a middle name.
Yeah,
that's all.
What happened is that actually they have to first correct the birth certificate. Then once the birth certificate is corrected, then the committee has absolutely no problem to issue certificate. Otherwise, there'll be two ST certificates for the one person, Your Lordship.
My Lord, if I can kindly take your attention to the rejoinder filed by the petitioner.
Yes.
My Lord, we have already applied for a fresh birth certificate because after we have made made this online application, they had insisted that we submit a new birth certificate with the changes accordingly, in accordance with the adoption order. So we have also.
But then this birth certificate is already annexed with the correct name.
We have already annexed them.
That is the different birth certificate. Now, once we issue the ST certificate, we have to issue only as part the birth certificate.
The birth certificate's got a correct name now, Frankie Miller Nongspong. You haven't seen the rejoinder?
I have checked that their office, but they said that I don't know. Because I
what do you mean, Mr. Abraham?
Miscommunication. Before I checked from the office this rejoinder, but it was.
Suspend that officer. Call you. Tell RP General if this is the way the government office functions.
Status online Khasi trips.
Anyway, 1 month's time, then the matter will be taken up before the committee. Then we'll decide, Your Lordship.
My Lord, after we've made this application, we have circled back to the same point where they're asking for the Khasi tribe certificate, my Lord. And this document would show the current status.
No, because that's generated by the machine. It is not. It's not something which goes through through a human interface.
My Lord.
That's the problem. This is a.
My Lord, the application when it's submitted, it does go through a particular person within the office of the district.
So that's what you won't take the trouble. There's just feed it to machine. It's like for every one of us here, though exempted 1026, you give the scheduled tribe certificate, you give your exemption certificate, and the machine still deducts all the TDS. Then what are you going to do?
No.
Yes, take down. The writ petitioner. Who is the adoptive mother of one Master Frankie Nongspong, who was born on 6/5/2008. Is before this court for directions to issue to the respondents for reconsideration of a representation dated 9/6/2023. Correct this one? For change stroke modification of the name of the child from Frankie Nongspung to Frankie Miller Nongspung in the Scheduled Tribe certificate. Stop. Next line. Mr. Michel, the counsel of the petitioner, submits that the petitioner has been compelled to approach this court in view of the fact that though the child already possesses an existing Scheduled Tribe certificate issued by the competent authority, when the representation was made for change and modification of the name, the respondent number, additional commissioner respondent number so and so, by letter dated 19/6/2023, have sought further requirements which are contained in the said letter, such as birth certificate of applicant with correct parent's name, comma, NOC from clan, comma, Khasi tribe certificate from KHDC, and so on. So, it has been submitted by the council that these requirements the set requirements asked by the respondent number so and so do not apply to the case of the writ petitioners to the child, inasmuch as a Scheduled Tribe certificate dated 22/10/2014 had already been issued to to Frankie Nongspung, and his being a member of the Scheduled Tribe is not in question or disputed in any manner. So we therefore praise that the respondent be directed to address the representation and to issue the required certificate as per required Scheduled Tribe certificate. Stop. Next paragraph. Mr. H. Abraham, learned counsel for the, what do you have to say?
The correct birth certificate has to be issued because once.
That's all.
Because if the birth certificate does not tally with the certificate.
Mr. H. Abraham, learned counsel for the learned GA on behalf of respondents, has submitted that notwithstanding other requirements which may not be deemed necessary, a correct birth certificate showing the name under which the Scheduled Tribe certificate is to be issued should be produced before the competent authority. Stop. He further submits that if the same is complied with, the respondents will process and dispose of the representation of the petitioner within a period of
1 month.
1 month. Yes, next paragraph. At this juncture, Mr. Michel has drawn attention of the court to the joint affidavit filed on 28/2/2024, wherein at annexure 2 thereof, a birth certificate issued on 19/2/2022 shows that 24 shows that the name of the child has been shown as Frankie Miller Nongspung. As such, he submits there should be no impediment for the respondents to grant the certificate in the correct name. Next paragraph. Having heard the counsel for the parties, in view of the short matter in issue, and as in very short matter, it is directed that the respondents, as everything seems to be in order and the requirements given in letter dated, does it letter page 33, letter dated
19/6 2023.
Letter dated 19/6/2023, seeming to be misplaced. Voulez bien? In view of the short matter issue is, as everything seems to be in order, seeming to be misplaced, shall dispose of the representation of the writ petitioner in a period of 1 month from the date of submission of the order, of filing the order, third copy of the order, before said respondent. Yes.
Hello, pleasure.
32.
Yes.
Lordship. The petitioner was enrolled in Assam Rifle, Lordship, as a cook.
This other matter before that, which was passed over. You ready? You call the other matter first?
Yes.
Okay.
Supplementary 8.
42. Something again. 42. 40.
Custom sector. Lordship, this is a writ petition wherein a person was traveling from Imphal to Delhi. He was a domestic passenger and he was wearing a gold kada, gold bangle.
Imphal to New Delhi by air. He was about to travel and the CISF at the airport held him, detained him, that you were trying to, the allegation is that you were trying to smuggle gold, a gold bangle, and he was handed over to the customs. The customs detained the said gold bangle and let him free. Thereafter, a show cause notice was supposed to be issued within a time period of 6 months as per section 124 of the Customs Act, read with 110(2). Now, the said show cause notice was not issued within the prescribed time period of 6 months. Now, my petition stands, my prayer is that the said seized gold kada may be returned as per section 110(2). What is the value?
The value is somewhere around 11 lakhs, my lordship.
How many grams was it?
It's about 197 grams. 197 grams.
Okay.
Now the issue, we are not going into the merits of the case, whether he has imported, whether he is smuggled, or although we have placed on record the bill of purchase of the said gold, but this writ petition is only limited to the fact that the said seized gold, as per the Act, should be returned if the show cause notice is not issued within the prescribed period. Now, we filed the writ petition, they filed the counter affidavit, and we filed the rejoinder as well, my lordship. Today is for the arguments. In their rejoinder, in their counter affidavit, admittedly, they have admitted in para number 10 and 12 that there is a delay in giving the show cause notice. Reasons
How do
they
they
have
explain
given.
that?
My lordship?
How do they explain the delay? How have they explained the delay?
I didn't follow.
How have they explained the delay?
The delay, they are saying that it was due to the some internet issues, and there was some violence going on in Imphal, in Manipur. So they are saying that there was some curfew. Due to that, they could not. Although there is a judgment of the Honorable Supreme Court I have placed on record, the delay even for 1 day is not permissible. And apart from them, majorly, there is a clause, section 110(2) clearly says, if in any case for whatsoever reason, if they are not able to issue the show cause notice within the prescribed time, there is a provision to take an extension for another 6 months, and that too in their own office. They don't have to go outside and ask for anything. So if your my lordship may allow me, I will just read that section 110 to
110.2.
Yes, my lordship. It's also part of my petition.
Yes.
Lordship, may I read?
Yes.
110.2, where any goods are seized under subsection 1 and no notice in respect thereof is given under clause A of section 124 within 6 months of the seizure of the goods shall be returned to the person from whose possession they were seized. Furthermore, my lordship, provided that the aforesaid period of 6 months may, on sufficient cause being shown, be extended by the Principal Commissioner of Customs or Commissioner of Customs for a period not exceeding 6 months. So they excuse that there was curfew, because the curfew or the violence was since May 2023. It was not that all of a sudden it had happened on this very same day. It was continuing for several months prior to the offence, to the alleged offence.
When did it happen, the seizure?
Sir, my lordship, the seizure was on 4th of April 2023.
4th of April?
2023. Seizure was made on 4th of April 2023. And 6 months time period lapse on 3rd of October 2023. In fact, the show cause notice has been digitally signed by the commissioner, by the learned, I mean, whatever the authority is, on 3rd of October itself. They have signed it on 3rd of October, that is on the last date. But they have not, further they had not given it to the petitioner. The mode of giving the notice lies in section 153 of the Act.
Okay.
If my lordship may kindly see section 153. May I read, my lordship?
Yes.
Section 153, modes of service of notice, order, etc. An order, decision, summons, notice, or any other communication under this Act or the rules made thereunder may be served in any of the following modes, namely, by giving or tendering it directly to the addressee or the importer or exporter or his customs broker or his authorized representative, including employee, advocate, or any other person, or to any adult member of his family residing with him. B, by a registered post or speed post or courier with acknowledgement due, delivered to the person for whom it is issued, or it is or to his authorized representative, if any, at his last known place of business or residence. So there are several other ways also, by email and other, but the section 153(1)(b) they have opted for, that is the speed post, which has been given for speed post on 5th of October.
Okay.
So it is beyond the permissible limit.
Seizure was made on April?
4th April, my lordship.
4th April, okay.
Must have been given on or before 3rd of October.
Yes.
But was given on 5th of October and reached the petitioner on 10th of October. Now, my lordship, I would just...
already resident of?
He's a resident of Rajasthan, otherwise.
Okay.
And he's a jeweler by nature also. He has a small shop. And, my lordship, one more thing. I would just like to draw your attention to the judgment of the Honorable Supreme Court. Actually, it's a judgment of the Honorable High Court, but since it was challenged by the DRI, the Supreme Court, Honorable Supreme Court has upheld the High Court order. That's on page number 83 of
your writ petition.
Of the writ petition. Lordship, annexure P9.
(82).
83, Lordship. It's that's the Supreme Court order, and it's on the next page is the High Court order. 83.
No, 79 is High Court of Delhi.
I'm sorry, my lordship. It's 82, my lordship. I'm sorry. There's a
Page?
mistake. Page 82, my lordship. Purushottam Jujodia.
The Delhi High Court.
Yes, my lordship. It's a Honorable Delhi High Court judgment which has been upheld by the Honorable Supreme Court. If my lordship may allow me, I'll just read a few paragraphs.
Yes.
Initially, the head notes, my lordship, seize goods, release of when no show cause notice issued on last date of limitation, but received by party after expiry of limitation for issue of such notice. Requirement that notice be given, meaning of when goods are proposed to be confiscated or penalty imposed, person concerned has to be notified of the grounds thereof. This can only happen when the person from whom goods have been seized receives the notice and understands the grounds proposed. Notice can be regarded as having been given when it is actually received or deemed to be received by the person from whom the goods have been seized. And same gives the person an opportunity to make a representation in writing so that order confiscating or not confiscating the goods may be passed. Thus, mere issuance or dispatch of notice would not amount to giving of notice. Instead, giving would be complete if the notice reached the person concerned or if notice, after having been rendered, had been refused. Issuance of notice within stipulated periods is thus different from giving of notice. On facts, my lordship, notices having been received after expiry of time stipulated being issued on the last date thereof, such that they could not be considered as given within the stipulated time stipulated, orders passed for release of goods of petitioners. Lordship, I would just like to draw your attention to para number 12, which is giving an explanation. Lordship, may I read, my lordship? Para number 12. On a plain reading of section 110(2) of the said Act, it is evident that the goods which have been seized under 110(1) of the said Act cannot be retained beyond the stipulated period of 6 months or the extended period of a further 6 months, if no notice is in respect of the goods is given under section 124A of the said Act within the said period. Section 124A of the said Act clearly stipulates that no order confiscating any goods or imposing any penalty on any person shall be made unless the owner of the goods or such person is given a notice in writing, informing him of the grounds on which it is proposed to confiscate the goods or to impose a penalty. It is evident that no order of confiscation can be passed unless and until such notice is given to the concerned person. My lordship, in the end, they have finally released the goods, and the Honorable Supreme Court, because this order was challenged before the Honorable Supreme Court on page number 92, Annexure P9, it is very clearly mentioned the interlocutory applications for modification of court's order dated 17 March 2015 stand rejected. Goods shall be released within a week from today. Lordship, it's page 92? Page 92, Lordship, Annexure P9.
Oh, it's just a note.
It's an order, my lordship.
Okay.
There are several other judgments also, my lordship.
So your ground is that even if it's issued on the last date, if it's not received within the stipulated time, will not amount to a notice.
The question is, my lordship, it should have been dispatched, even if it was dispatched on the last date.
Even then,
it would have been fine, because they have done their obligation. But signing it and keeping it in their own office will not serve the purpose, my lordship. It is not given.
My lord, our only submission, my lord, because of the law and order situation in Manipur that point of time, internet were shut down, my lord.
But then can it go above the statute? Any other circumstances? 6 months' time was.
My lord, in my humble submission, this section 110 cannot be given that kind of pedantic interpretation, my lord.
Can it be in such a
because that is
interpretation?
interpreted in terms of the prevailing circumstances also, my lord.
You have any other authorities to show otherwise?
Because, my lord, we have taken, I don't have any authority today, my lord, but only two aspects which we have stated in our affidavit, my lord.
Yes.
At page 6, para 12A, my lord.
Yes.
That is, so-cause notice was issued on 3/10/23 as per the proviso to section 124 of the Customs Act, void letter number so-and-so, dated 3/10/23 and generated under deed number so-and-so on 3/10/23. However, due to imposition of strict curfew by local CSOs and the district magistrates within Impal and adjoining areas arising out of the ongoing communal conflicts erupted since 3rd May 23, the SCN could not be sent to the notice by post on 3/10/23, and such the same was sent through speed post could only be sent only on 5/10/23 when the curfew was relaxed by the administration.
That's the only reason. Then when that happened, and why didn't you, the Customs Office itself extended another 6 months? When it could not be sent on that day?
My lord, we signed, we did everything on 3rd October, my lord.
If you couldn't, then why couldn't the, it's not that they can't do it, to extend the period by 6 months, why?
Because 3rd, 4th and 5th, my lord. The timing is so close, my lord. By the time we take, because the commissioner has to...
So why do you wait till last minute? If the seizure was done since 4th of April, why do you wait till 5th October?
But that was also because of the law and order situation, my
lord. 4th of April, there was no law and order situation. You had a clear 1 month.
But from 3rd May, the situation wasn't.
4th April, a seizure was
4th April,
done.
my lord, by the time we recorded the statement and other things, my lord. Because we have to, after investigation, we have to issue the so-cause notice, my lord.
Can this be a ground for, bypassing the statutory requirements?
In my humble submission, my lord, though, as far as COVID situation is concerned, my lord, there I found some authorities.
Supreme Court saying regarding limitation.
My lord.
But can it go over?
But that COVID, this is beyond the period of that COVID extension by the Supreme Court, my lord. And this is not because of COVID, my lord. This is because of peculiar situation of the Manipur, my lord, that point of time. That is one aspect, my lord. My lord, the second aspect which you have cited, my lord, I just refer to subpara B of para 12, and you have quoted 2 judgments of the Supreme Court, my lord. Because this release under 110(2), my lord, is only for the purpose of release. The proceedings will still continue, my lord.
Of course.
But this is a second limb of argument, my lord. Our main thrust is that because of the situation prevailing at that point in time, because internet is provided under section 153, my lord, but even internet is...
Internet was not blocked for several government functionaries, the secretariat and the other, police authorities.
During that period of time, what they said...
I don't think this court, it is for the public maybe, why, data, but regarding fixed internet...
In para 10, my lord, we have stated that there was a restriction on internet.
Para 10 way?
Para 10 of the affidavit, my lord. On the second page, your lordship, page 6. Imposition of strict curfew by local CSOs and district magistrates in Manipur during the period it caused difficulty with the ban on internet connection across the state of Manipur. Sending of documents through e-office for issuance was also one of the main hindrances and thus delayed in issuance of the SCN.
What are local CSOs?
Civil Service Authorities.
Will these circumstances carve an exception?
In my humble submission, my lord, when something
it amounts to the conditional contract, war, act of war, force majeure.
It's a situation of act of war, more or less, internal war.
How do you see it issued on 3/10? What is the factum to show that you said it's issued on 3rd of October? How do you support the statement you've made?
Page 23 of the red petition. Page 32, Your Lordship. Digital signature of
32 or 33?
Page 32. Date 3/10/23.
32?
Page 32 of the writ petition.
No, Shuk was issued from Manipur, issued from Shillong. Let's see your the heading of the office. Shuk of notice. Where is that? This notice, where is the Shuk of notice?
Lordship is from Shillong.
Then your excuse falls flat.
And it's the office of the Commissioner of Customs.
See, 110 MG Road, next door from here. Dr. Mozika, how is this prepared?
If that is the case, it is an incorrect statement.
Incorrect statement, you have to withdraw the affidavit. Otherwise, it amounts to.
Lordship, moreover, we are not challenging the validity of the notice. We are not challenging the seizure. We are simply saying that, as per the Act, the goods should be returned.
Yes,
They
we'll
will
pass
continue
orders.
with the process of law, whatever.
We'll pass orders then. Yes.
Only one observation, my lord, that the proceedings will not terminate because of this.
Why should the police terminate? It's only the regard of the release of the seized article. Yes.
32.
Highly obliged, Lordship.
Thank you.
Yes,
Lordship. The petitioner was enrolled in Assam Rifle in the year 1985 as a cook, Lordship.
85 as a cook?
As a cook, 1985 as a cook. And on 11/8/2014, he was issued with a order that he had completed 30 years of service and he will go for premature retirement. And this was by taking recourse to Rule 48 of the CCS pension rule. So the petitioner had challenged, assailed that order before this honorable court, and which was registered as writ petition 101 of 2015.
Oh, earlier one.
Earlier
second
one.
time you've come?
Yes, Lordship.
Okay. The what order was passed?
So that writ petition was pending, and then the interim order was also in favor of the
Where is
petition.
this order?
Interim order is at page. Page 27 and 28 of the writ petition. Of the writ petition. Page 28 is the relevant, Lordship. The interim order passed earlier shall continue until further order. The petitioner was retained in service, and the writ petition was finally heard, Lordship. And white order dated, a judgment and order dated 15/6/2016. 15/3/2016. The same was dismissed. There are 60 numbers of writ petitions.
Yours was dismissed also.
Was one
Very
of
good.
mine.
Then what
That is
happened?
at page number 41. 41.
That number it was 101, you said?
101, Lordship.
101,2015.
2015. So that was dismissed. In the meantime, what will happen, Lordship? Some other
Your
colleagues.
Oh, Rifleman Cook.
Rifleman
Dharamveer
Cook,
Singh.
Lordship, Dharamveer Singh.
Okay, where's the dismissal order? Last part?
Last part is at page number
69.
Yes, Lordship. 78 onward.
Okay.
Or 97, page 97 onward. So, in the meantime, some other personnels were also given similar order. that they will prematurely retire. And those had, some of them had approached the Guwahati High Court. And the Honorable Single Judge of Guwahati High Court, White judgment and order dated 15/6/2016.
Where is that?
That is at page number 104. Had allowed those writ petition. The relevant part will be is page 137.
104, some annexure 4, what's this?
Annexure 5, this is.
Annexure 5 is page 109.
Page 137 is the operative part.
How many cases were taken together here?
Together at that time it was around 17?
More than 70 cases.
More than 70 cases.
So those writ petitions were allowed.
Similar situation.
Similarly situated, similar type of orders.
Then what happened?
Holding that the Assam Rifle Rule 26 was not followed.
Okay.
And in the meantime, those writ petition, which 60 numbers of writ petition which was dismissed by the single judge of this honorable court, some of the writ petitioner had filed appeal.
Before this
division bench. And those were taken up, and White judgment and order dated 23rd October 2017. Those writ appeals were disposed of by directing the, not allowing, by with an order that the restoring the writ petitions to be decided afresh.
Okay.
Per qua the petitioners writ appellant who were there. So those writ petitions were disposed of by this honorable court by judgment and order dated 31/8/2022. That is at Annexure 11, page 169.
Okay. Yes.
So here the honorable this court has allowed the writ petition by ordering the respondent authorities that they must be reinstated in service, and whatever pension amounts they have taken, that may be adjusted with the pay and salary.
Now what is your age?
Age is, Lordship, I have given
age?
58.
Only 58 was the point of continuing service.
2 years is left, Lordship.
These people came in 2015. They filed. No, 2015.
2015, yes.
You didn't prefer an appeal.
Yes,
the
yes,
judgment
Lordship,
came
because of the
from Guwahati High Court in
circumstances.
16.
Yes.
Correct. Then after it came 16, then these people preferred. Was the appeal delayed before this court? It was delayed, condoned.
Appeal was immediately filed by some of the other petitioners.
Against the early order?
Earlier order.
Okay, they all did appeals.
And in the appeal, they have
remanded back.
Yes, Lordship. They have missed. Because immediately after the dismissal of the writ petition, orders were passed that to leave the camp and all unit, and the PPO was dispatched to their respective.
Now you and certain other people yet filed the writ petitions.
Yes.
Correct? Interim was operated. You were enjoying it.
Yes.
Then finally got dismissed. Now some people, some of those writ petitioners, in their petitions they filed an appeal. Correct?
Yes,
immediately after that.
Yes.
And in the intervening period, the judgment came from Guwahati High Court also.
Yes.
Allowing the other assemblies out there in Guwahati.
Yes.
So then the writ appeal court here said that, okay, fine, remanded it back to the single judge to decide afresh.
Because in the Guwahati High Court.
And then decided afresh, these writ petitions were allowed.
In the Guwahati High Court, Lordship, against the order of the single judge, the department has filed an appeal. The writ appeal was also dismissed. And against that order of the writ appeal, preferred SLP, that was also dismissed. So that order of the...
You were nowhere in the picture.
Yes, I was no one in the picture, but the facts remains that the orders were bad in law, and that's why those orders were interfered.
Getting this thing after 15. Now when is this writ petition filed?
Writ petition is
23.
523, Lordship, because
Then?
of the pendency of the other writ petitions which were remanded back.
So you're sitting on the fence looking.
Yes.
What will happen?
Yes.
If it went bad, then you won't have.
That is the explanation given also, Lordship.
You're just sitting on the fence and watching the game.
And one more.
And I saw that your team's winning, then you went inside.
The delay is there, Lordship, that I admit. And one more, for the period when the interim order was passed, I have worked for 6 months, around 6 months. For that also, Lordship, not paid. And that is clear from the. Yes, that is very much clear from the annexure.
I don't think at this late stage, Mr. Upadhyay, notwithstanding even how good your case is.
Annexure 12, Lordship.
Notwithstanding good case, will this court accept and allow you to roll back the years to 2014?
15.
That much they can consider, Lordship, of the period which I have worked. And that is by the order of the court, Lordship.
If he has worked, definitely he has to be paid.
Entitled to the period you
that is the commencement of the pension is 1/6/2015. That is the date which they have intimated in their impugn order. That from that date, my retirement date is.
So after retirement order was given and you came for this court?
Yes, Lordship. Then
you continued to work for how many months?
Up to March 2000.
Up to March 17.
16.
March 16.
Lordship. Because the order has judgment and order is of 15/3/2016.
Yeah, Dr. Musika.
That is the second prayer of this writ petition.
First prayer, you're just watching the game.
That is of the delay and latches that I have explained in my writ petition. That is convincing.
It appears, my lord, from the affidavit, my lord, at page 5, that it says, my lord, if I just read one sentence. Accordingly, the petitioner was ordered to retire from service on retiring pension with effect from 1/6/15.
Just 1 second. Where are you reading from?
Page 5, subpara F, my lord. The last sentence.
Last sentence.
Yes.
My lord, there's no clarity on that. But if Lordship may direct, my lord, if that has not been paid, he'll be paid, my lord.
That aspect they can re-examine that aspect at least.
Yes.
My lord, date of discharge is 1/6.
Just 1 second. His initial date of discharge was, I mean, after that, you see that?
1/6/2015 was the date of discharge, my lord.
1 second. Page 5.
Page 5, my lord. Last sentence of para F, my lord.
Okay.
So it appears that from 1/6/15 till 15th March 16, he might have served, my lord.
From?
From 1/6/15, or from the date of interim order, my lord. Date of interim order is
page 27. 27 and 28. 14/5.
Give the date interim order.
14/5/2015.
14/5/2015. Do you work till 15/3/2016?
Lordship.
And okay, and the thing is that
the whole of March.
Whole of March. Okay, till 31/03/2016. And then
he's out from services then, my lord. He never filed an appeal.
Yes. Yes, from 1/6/2015. See, Mr. Upadhyay, after you're given the order of discharge final, after your case was dismissed, then you didn't file an appeal.
No.
And the thing that goes against you is that You submitted all your pensionary papers and everything as required.
Yes.
For payment of pension.
Lordship,
that
those-
means he had already acceded to the the situation.
No, those were taken prior to dismissal of the writ petition.
Okay. You do medical category.
A low medical category of suffering from obesity.
Nachi, how would have? But you're
He's
a cook. You're a cook, so Nachi,
Yes,
you'll
that's
be
all.
fat. Yeah. So that's eating all of Jawan's food. Yes. Take down.
What?
So excuse me. By way of the instructed application, the writ petitioner where is your prayer?
Page 2 of my affidavit, my lord. The facts are narrated them.
No, the prayer, honestly the prayer. What he's seeking in this prayer.
Number one is that the judgment
No, I'm
and
going
order
I'm
which
for your
is
prayer in the writ petition.
Page 21, my lord.
Page 21.
Tom, no? Is seeking reinstatement of his services by extending the benefits of a judgment and order dated 31/8/2022 passed in WPC number 62/2015 along with other connected petitions, and also for payment of allowances and admissible dues for the period from March 2015
June 15, my lord.
to when is interim order?
1/6/15.
Interim order is?
My lord, interim order was because he approached court earlier than his due date of discharge, my lord. His due
Okay.
date of discharge was 1/6/15.
1/6/15.
My lord. 1 June 2015.
His duty is 1/6/15.
My lord.
Then he approached court. Then he worked by virtue of interim order
Till it was dismissed on
15/3/2000.
15/3/2016.
2016.
2016.
Wait, how no? For a period up to 1st of June 2016. Stop. Next paragraph. The brief facts which are necessary for the instant, brief facts necessary are that the writ petitioner who was serving as rifleman cook had enrolled in the Assam Rifles on 28/5/1985, and under the provisions of Rule 48, Roman 1, normal 1, then bracket B, of Central Civil Services bracket Pension Rules 1972, and Directorate General Assam Rifles Policy Letter Number dated 18 November 2004. Dated 18 November 2004. Having been found unfit for retention and service beyond 30 years service, were retired from service on 1/6/2015. Stop. The petitioner at that point of time, being aggrieved with the said order of retirement, had then filed writ petition being WPC number 101 of 2015. And this court had then, by order dated
15/3/2016.
No, interim order.
Interim order is
14/5/2015.
By order by
14/5/2015.
By order date 14/5/2015, as an interim measure, has stayed the said order of retirement. And as such, the petitioner continued in service. The writ petition then came to be dismissed by order dated
15/3/2016.
15/3/2016. No.
15th March 2016.
15 March 2016.
Yes, it can be dismissed by
page 72.
By a common judgment order dated 15 March 2016. And as such, as per the directions of the court, the petitioner stood retired. Stop. It is also It is also noteworthy that the petitioner had by then submitted his pensionary papers for payment of pension. Stop. It appears that before the Guwahati High Court, similar matters had been agitated, wherein by order dated, where's the order dated? 16, right?
15/6/2016.
Order dated
15/6/2016.
2016.
Page 121 of the
Page 121. Passed in a bunch of writ petitions. Bunch of petitions. 121.
121 is the date of the date mentioned.
And a conclusion, where is it?
Conclusion is at page 137.
The orders of premature retirement were found legally unsustainable and were set aside and quashed. Parallelly, are you right? Next paragraph. Parallelly, the other writ petitioners in the other connected petitions, which had come to be dismissed together with the petition of the petitioner, had preferred writ appeals before the division bench of this court. Whereafter, on hearing, the same were remanded for fresh reconsideration before the single bench. Is that correct? Single bench. These matters then came to be disposed of by an order dated 31st August 2022, allowing the same and directions passed therein for reinstatement and for payment of arrears, salary and allowances as due and payable. Stop. Next paragraph. It is in this backdrop that the writ petitioner, who had abandoned proceedings before the court after being unsuccessful in WPC 1110, 101, has now sought for directions that the benefits of the order dated 31/8/2022 will also be extended and he be reinstated in service. He be reinstated in service. Stop. Next paragraph. Mr. S.D. Upadhyay, the counsel petitioner, has submitted that though it is not disputed that after the said dismissal in the first round litigation, the petitioner had not agitated for its rights, but contends that the fact that other similarly situated petitioners have been granted relief, no discrimination can be accorded to him, and he should be given similar treatment and allowed to continue in service. He further submits that even for the period for which he served, by virtue of the interim orders passed by this court, he has not received the pay and allowances as admissible. He therefore prays that appropriate directions be passed for his reinstatement in service and for further directions for payment of the period that has remained unpaid. Next paragraph. Dr. N. Mozika, the DSCI, with so-and-so, has contended that the writ petition is hopelessly barred by the laches of the writ petitioner, who, after judgment had been rendered in the WC 101 of 2015, accepted the same and it proceeded in retirement. He submits that on this ground alone, no consideration can be given to the writ petitioner, who has not been vigilant to safeguard his rights or agitate for the same. Stop. With regard to the period served under the interim orders of this court, the learned senior counsel submits that if the submission is correct, then whatever legitimate dues are payable, the same will be disbursed to the writ petitioner. Stop. Next paragraph. I've heard as counsel for the parties. It is not disputed that in similar other matters where the parties have been vigilant and pursued the matter to logical conclusion, they have obtained the fruits of litigation and have been reinstated in service, with their orders of premature retirement being quashed. Stop. The aspect of delay, however, has to be viewed very seriously by this court, inasmuch as, the writ petitioner, as is patent from the materials on record and as per the pleadings, had for all purposes abandoned his case. And after how many years? 23, 15, after 8 years, has, by way of this instant repetition, resorted to a fishing expedition in the hope that some relief might be forthcoming. Stop. Next paragraph. Without adverting to any authorities on the matter, it's been settled that delay is a factor that cannot be ignored, except for circumstances which are beyond the control of the petitioner or parties. In the instant case, no reason has been made out, nor any explanation offered as to what prevented the writ petitioner from pursuing this legal remedy under the court. And as fairly conceded by the counsel for writ petitioner, if in the event the min prayer could not be granted, perhaps the court may consider the second prayer for payment of legitimate dues if admissible. In his view of the matter, the writ petition being hopelessly delayed by the laches and lapses on the part of the petitioner, the relief as claimed at this stage, after such a long delay, cannot be granted. But however, the respondents are directed to examine the aspect of the payment of pay and allowances of the writ petitioner for the period he served after the interim order was passed by this court till the dismissal of WC 101 or 115 thereof. With therefore direction, the petition stands disposed of.
After adjusting the amount which he had received.
It is understood that the matter, the dues shall be adjusted against paid pensions that have already been received. Sorry, Mr. Upadhyay.
34.
Deeply.
Yes, Mr. Pathak. Where is he?
My lord.
Yes.
Yes. Vasudevan Patti, my lord. Item 35.
34.
34, my lord. Yes, my lord. This was a matter relating to transfer, where we had only posed the limited question that in the affidavit filed by the Assam Rifles, it was stated that the choice posting that I had given, my lord, they said that there are no vacancies available in those particular stations, my lord. In such circumstances, my lord, I had requested if, my lord, alternative posting choices can be given in which they can consider me, my lord.
So
to that extent, probably Dr. Modika was supposed to have instructions.
He's on the last hearing, Mr. Pathak sought leave that if we can submit a fresh representation, my lord, and that may be
my lord
considered by the department.
If that can be done, my lord, we can close it in that line, my lord.
That will be considered
because
as per the policy, my lord, by the government. Matter can be closed.
My lord. Because I am posted still at Kashmir. The posting movement order has not come.
Okay, take down.
She will only record that the choices I had given earlier, they say that there are no vacancies in those choices.
Understood. Yes.
So if I can represent in other choice stations, my lord.
Yes. The petitioner is serving as what is the second in charge command? Second commander.
Second in command. Who is
my lord? Who is
Kashmir.
Is in Kashmir now.
We're not supposed to give the location, correct? The petitioner who stated to be serving as a second in charge.
Second in command.
Second command. In the 26 Assam Rifles had filed a representation dated 13/7/2023 with a prayer. He's going to retire, and how is that possible?
My lord, I'm going to retire in
when are you going to retire?
26, my lord. So this will be my last leg posting.
When
so
did you retire?
In
2026, my lord.
Still has 2 years.
May 2026, my lord.
May 2026. 31st May. You
There's
23 here.
May 2026.
Yes.
More, my lord, that might be overlooking in the typing, my lord.
The prayer that as he was to superannuate on 31/5/2026 as last leg posting, he may be transferred and posted on a place of his choice. Stop. The same, however, came to be rejected by the order dated 20th/9/2023, and the petitioner, being aggrieved thereby, has approached this court by citing the transfer policy of some rifles, more particularly clause 16, which provides for consideration of transfer based on compassionate problems. Next matter, Mr. P. Pathak, the counsel for petitioner, has submitted that the rejection, that the respondents were rejecting the request of the writ petitioner did not consider the same from the angle of last leg posting, which in his opinion is unreasonable and harsh. Stop. Prayer had been made then. Which stations did he want?
Well, earlier he wanted.
Prayer had been made in representation.
Earlier we had prayed for Delhi, Sukhoi and Lokra, my lord. Lokra.
Yes. Prayer had been made, he submitted initially, for posting the writ petitioner. Where do you find that?
Page 2 of my affidavit, my lord.
For posting the writ petitioner.
What's the bottom? Page 2.
Page 2. In either of the 4 places, namely Delhi, Sukhovi, Sukhovi, Lokra, Lokra, and Ghaspani, which has been elaborated therein. Stop. Which has been elaborated in the representation. Stop. Next paragraph. Dr. N. Mozika, by way of affidavit, has placed an affidavit and relied on the same to advance the argument that the choice postings as requested by the writ petitioner,
either there are no posts or there are no vacancies, my lord.
Either presently no vacancies available or no posts exists for accommodation of the writ petitioner. He has fairly submitted that in the event the writ petitioner files a fresh representation for reconsideration to other stations of his choice, the same will be considered by the respondents.
In terms of the policy?
In terms of the existing policy.
My lord, my lord.
Next, Mr. B. Pathak to this suggestion praised that he praised that the writ petition may be closed at this stage and he'll be permitted to file a representation within?
My lord, 10 days, my lord.
Within 10 days.
Because he is in
for reconsideration by the respondents, together with liberty to file writ petition afresh, if so advised. Stop. Next paragraph. In consideration of submissions of the parties, this court in constitutional submission of parties, this writ petition is accordingly closed at this stage by allowing the writ petitioner to file a fresh representation indicating the choice of postings therein, and the same shall be considered by the respondent within a period of 4 weeks of receipt of said representation. Stop. Just to add, if a new cause of action arises, the writ petitioner has liberty to approach this court. Matter stands dispose of this.
In fact, Mr. Pathak wanted to file a representation. What did Pathak wanted to say?
Yes.
My lord, because in transfer, otherwise our rights are very limited.
Very limited.
We are at the mercy of the respondents only.
Yes.
Deeply.
Deeply.